All right, we've got Mr. Adegboruwa, Senior Advocate of Nigeria, joining us next. Good morning, and thank you for joining us. Let's start off from where we left off. What's your impression of how the coordination, the messaging as to what to do, how the authorities are handling COVID-19, how is it coming across to you?
Thank you. Good morning. I listened very well to the national coordinator, and indeed I have followed the activities of the presidential task force. And I believe that at this time we can only sympathize with the government, given the challenges that are associated with the COVID-19 pandemic. I see that we're having very daunting challenges that we all need to work with the government and cooperate towards tackling these challenges for the good of Nigeria. So to that extent, I must commend the presidential task force, the president himself and the governors, and indeed the National Council for Disease Control, Center for Disease Control. It's been quite stressing, especially when you consider the frontline workers, many of who are now being infected and have become victims. So we need to sympathize with government because it's a global challenge. But I think that from the experience of many Nigerians and from what we see on the ground, there's need to improve capacity. That is very vital at the stage we are now in our national life. There has to be some form of alignment between the reality of the pandemic and then information management. Like you have analyzed in the course of your presentation earlier, there's trust deficiency. Presently, the issues of the past in terms of deficiency of integrity of government in respect of information is affecting people's perspective. I have gone through this system recently. I had a personal friend who had a challenge, and it took an SOS for us to get a friend tested. And over a week after the test, we don't have the results, even up to now as I speak with you. So, and this is like what is going on virtually in everywhere. So I'm saying that even though we don't want to raise unnecessary alarm and cause people to panic, we must let people know the actual situation of what is on ground. As in, from what I can see now, is either that there are no testing kits or that there are too many people who want to be tested and there's no capacity to handle that. Then secondly, Mr. Chamberlain, is the issue of government responsibility. Under Section 14 of our Constitution, the primary purpose why a government exists is to cater for the welfare and security of the people. Welfare has to do with the economy, food, palliatives, and security has to do with protection of lives and property. So, and from the analysis of the situation so far, the reason the lockdown was eased is because government just wants to throw us to the situation to say to your tents, oh Nigerians, go and cater for yourself. We don't have resources to distribute palliatives, and then we cannot protect you. And so you go there, fend for yourself, protect yourself, and then battle with COVID-19, which I think is quite an unfortunate development. But like I said, government deserves our sympathy, and I do sympathize. But I think there is a lot more that can be done to coordinate this system rather than this haphazard measure that we see now. Take a look at Lagos. Since Monday, the crisis that we have, people who work in Lagos are staying in the hinterlands, Mowe, Ibafor, border towns in Ogun State, and the same with the FCT. People who work in the Federal Capital Territory are either coming from Nasarawa State or Niger State, Yanya, Karu. And so you see the crisis that we are currently undergoing in terms of interstate lockdown and then the curfew. People are still on the road by 12 p.m. trying to get into their places. And at times, policemen they ask them to stay till the following day. So I think that these are challenges that, having experimented with these 3 days, there's need to lift the curfew and then to lift the interstate borders and allow those who want to make a little living for themselves to move around. That's
Okay.
very important.
All right. Well, perhaps we'll leave that to. Well, there are so many issues to raise about that one, but we could go on and on. But one of the sectors that the easing of the lockdown has affected slightly is, of course, your sector, which is the judiciary. Now, there seems to be a new normal playing out in the judiciary with the e-sitting experimented in Lagos, and a number of challenges have been raised: power, internet infrastructure, and all of that. But talking about the process, the judicial process, court processes, in what way is this e-sitting going to affect the normal, the former normal in the judiciary, in the court processes?
Well, I think just like the COVID-19 pandemic, what we're going through is novel, and we should all embrace all policies that are geared towards ensuring efficiency. Before now, we've had challenges with the issue of administration of justice, especially criminal justice system. The delays, it takes average 8 years for you to prosecute a case in the court to conclusion, to get judgment. And probably for you to prosecute an appeal from there to the Supreme Court will take about 20 years. And so we've been looking at what to do to get over these challenges. So I think COVID-19 has actually now provided an opportunity for us to examine our system of justice administration and profile solutions that can ensure that people have true justice. I watched the proceedings in Borno State and the proceedings in Lagos State, and I'm told that 3 other proceedings held yesterday at the Federal Capital Territory High Court. The one in Borno State was only delivering a judgment, so we didn't have the opportunity to see how the whole trial went. And the one in Lagos also was to just deliver a judgment. So it's easy in that regard, if it's just to deliver a judgment or deliver a ruling. But when you talk about a defendant who is in prison or correctional center and is to give evidence, so you then ask yourself, who's going to provide the generator? Who's going to provide the laptop? Who's going to provide the computer? And then the lawyer cannot go to the prison to go and meet him there for the purpose of guiding him in presenting his evidence. The lawyer has to be in his house, and you have to be in a decent environment. That means you have to get a generator and power it, because you know the challenge with power system. So my concern is not that the system should not be embraced, but that the Constitution has granted a free access to justice in Section 6 of our Constitution. The court is meant to decide disputes between persons and persons, between persons and government, and between government and government. So in that regard, what is on my mind is the person in the village. What is on my mind is a worker who has been denied a right of access to employment, and he wants to challenge it. What is on my mind is somebody who is in custody and wants to be free and argue his application. Can these people have access to efficient data system? Can they have the gadgets, the laptop, the iPad, the smartphones? Do they have the capacity to sustain electricity in order to participate in this system? So if we cannot guarantee the infrastructure, if you cannot lay the foundation, I don't think it's proper to just copy hook, line, and sinker what exists in other countries. Because of their own experience and exposure, they can afford to use Zoom and Skype to conduct proceedings. But with all due respect, given the level of illiteracy, the poverty, and the infrastructural deficiency in our country, I do not think it's proper to adopt virtual hearing to conduct trial proceedings that require calling evidence, that require tendering documents. And that's just a part. Even when we were going to court physically to conduct trials, it's a great challenge to authenticate the originality of documents to tender: certificate of occupancy, birth certificate, WAEC result, university certificates. And you see what is going on with politicians in all election petitions all over the country. So even physically, we have challenge in certifying documents to know that this one is genuine or this one is fake. And now when you throw these things on the internet, and you know how people are in our nation. I had an experience recently where somebody went to buy items in a shop, and he has to credit the account of the shop owner, and he was given an account, and he claimed that he had done so and produced evidence of credit alert on his phone. which was also sent to the other person, and he took the goods away, only to discover that transfer was fake. The money didn't go anywhere. He generated that credit alert through his phone and scammed the person. And so this will go on in respect of virtual hearings, where you can no longer trust the authenticity of documents to be uploaded and tendered, and it will affect contracts. It will affect people's destiny. You have gotten the judgment, you have gone. Before you get those things to reverse the judgment, it takes eternity.
The scenario you just painted, brings this to light. I mean, the possibilities that might come up in the event of this, being adopted full-fledged. But there's a dilemma here. Justice needs to be administered, and it appears that this might stay with us for a long time. In fact, the role of the judiciary was even put in that infectious disease bill, the magistrate court. So basically, we need the judiciary to work. So the question is, I think we'll need to go to break to get your concluding thoughts on that. But the question now is, what is the way out if we're looking at this staying with us for a long time? Well, the e-sitting has been tried, maybe not full-fledged, but you know what is the option you have on ground for us to get out of this and ensure that justice is still administered?
Well, thank you very much. As you see in the country, in spite of the COVID-19 pandemic, the ASO Villa is functioning, the presidency is working, governors are working, the executive is in full force, and just this week, the National Assembly has resumed. So I presume that two arms of government is dominating and oppressing the other arm. The presidency has facilities to sustain itself for the next 20 years, with or without COVID-19. The same with the National Assembly. They have the facilities, they have the space, they have the resources. You can't say that with the judiciary. Go to the courts in Lagos, and I'm sure you've been there many times. There are courtrooms where lawyers stand outside, and it is when they call their case that we go and call them, together with their clients. And it's all over like that in the country. There are courtrooms in Lagos State where you have no seat, and lawyers stand to conduct proceedings. So what the solution is, first of all, investment in infrastructure.
Okay, Mr. Adegboruwa, just a minute. I mean, now, students in universities who also stand outside know that it's not peculiar to them. But we'll come back and let you conclude your thoughts in just a moment. Please stay with us. Welcome back, Mr. But please go ahead and conclude your thoughts on the point you were making.
Yes, I was saying that we need to get our government to invest in infrastructure, and in particular within the judiciary. And that's what the Honorable Chief Judge of the FCT Judiciary has just mentioned. It's a lot of challenge when you look at a critical sector of our society, judiciary, suffering neglect and lack of funding. And we can't say it louder than to say that give us our money. Let it be drawn from the Consolidated Revenue Fund. Allow the Chief Judge to have access to that fund directly, not going through the Attorney General or going through the Accountant General, because it's a way of monitoring and exercising control on the judiciary when they still have to go to the executive to get their funding. Then secondly, we need to amend the Constitution. We need to amend our statutes and our relevant civil procedure laws. Under our Constitution presently, at least under Section 36, every defendant or any person accused of a criminal offense must be physically present in court. If he's to be arraigned, he must be there standing before the judge physically and be arraigned. And so it's going to be a challenge to interpret that a defendant or accused person who is in custody or in correctional center can be deemed to be present on Zoom or Skype before a judge. So my suggestion, therefore, is this. First of all, is to agree on a uniform procedure. Skype is universal. Zoom is universal. If Lagos State is going to adopt Zoom, if Abuja is going to adopt Zoom, if Kaduna is going to adopt Skype, let's agree on a uniform rule. Not that I practice Zoom in Lagos, by the time I get to Abeokuta, it's a different rule. By the time I get to Benin, or by the time I get to Kaduna, I meet a different set of rules. We're talking about technology, so it should be universal. And I'm sure that the National Judicial Council has already set up a committee that will come up with uniform rules that will guide the system.
Just add to this while you respond. Will that also take into cognizance the question of jurisdiction?
Well, jurisdiction has to do with the competence of the court that's judicial officer presiding, and then the subject matter of the suit. So by and large, that is purely a statutory matter, which is to be guided by statute books and case law. So far,
part of what I meant is that if, for instance, I did something in Lagos, I'm supposed to be charged in Lagos, and then via Zoom, I could remotely join anywhere and claim to be somewhere, would all of those be factored in?
Well, these are the things that we are looking at to tackle. Because Lagos State, for instance, is guided by what you call territorial jurisdiction. So Lagos cannot be claiming to exercise jurisdiction over somebody who is in Cross River. And, with Zoom and with internet, you never can determine the location of persons. That will not be a problem in civil cases, because wherever you are, you can give evidence. But surely in criminal cases, the defendant ought to physically be present within the jurisdiction of the court. So I think that the challenge we have is that we should use this system to address non-contentious applications where you don't require the presence of persons or the giving of oral testimony. You can take rulings, you can take interlocutory applications, you can take bail applications to decongest the correctional centers. And then you can use it for the appellate procedure, because there's backlog in the Court of Appeal and in the Supreme Court. So we can use this system to take those appeals, because to take an appeal, you don't require the presence of the litigant. The lawyer will just adopt his brief, and a time will be given when judgment will be delivered. The same thing in the Supreme Court. So I believe that this system is good. However, it should not be extended to the High Court for the conduct of trial proceedings, because that will create a lot of denial of access to justice, especially for the indigent litigants and for the illiterate persons who are in the hinterland, who are actually the subject matter of deprivation of justice. That's what I think should be looked into.
Well, let's just hope, just as you said, it is looked into, because indeed it's really the way to go. But let me just ask you this. Is there any way in which e-sitting or e-judiciary would affect jobs?
Well, I think not just in the judiciary, in the financial sector, in the generally in all sectors of the economy. The consequence of COVID-19 is that it will affect a lot of jobs because the requirement for manpower is reduced when you resort to virtual hearings or remote hearings to conduct business or judicial proceedings. So indeed, I'm afraid that it will affect a lot. But if you can graduate the hearing to ensure that we do e-filing in the court, whereby we don't need to go there physically, it will erase corruption in terms of payment to the actual purse of the judiciary, and then it will erase the delay in the time it takes to do these things. So surely it will affect a lot of jobs from the way I look at the conduct of the proceedings.
Another thing that a number of people have talked about, which you have also referenced earlier, is the kind of infrastructure to run this thing. One of those infrastructures will be judicial. Do you think there is any law that we will need to adjust to facilitate judicial proceedings via electronic means?
Yes. For you to do criminal proceedings online, you need to amend the Constitution, because in Nigeria, the court is deemed to be a public place where all citizens have right of access to enter the court, either to monitor proceedings or to partake in it. So the court is deemed to be a public arena, and you cannot deny anybody access thereto. But it's not the same with Skype. It's not the same with Zoom. And when you say, for instance, you want to determine whether a judge is biased in the proceedings, it is the thinking of the reasonable man who is watching the proceedings that you make that conclusion. But on Zoom, on Skype, it's limited to the judge, it's limited to the lawyers involved in the case, and indeed the litigants themselves. The public is already excluded. And that to me is a challenge, because the Constitution is very clear in Section 36 that the courtroom shall be open to all citizens and litigants, except those who misconduct or misbehave in the course of the proceedings. And to amend the Constitution, it requires the National Assembly and at least the houses of assembly of the states. That's the reason why I said this virtual hearing should only be used for non-contentious proceedings and the appellate cases. Secondly, when Raji Fashola was the governor of Lagos State, the courts were run are connected to an independent power system. And I don't see any reason why that should stop. I've attended court since last year or year before, and the judge will not sit because there is no supply of electricity. People are brought from custody, from correctional centers, and they are taken back, not for the fault of the litigants or the lawyers or the judge, but because of infrastructure. So unless we ensure that the courtroom is ventilated, is properly heated, and supplied with electricity, you'll be expecting the judge to be sitting at home to conduct virtual proceedings, to be using his own personal electricity, a judge who is not well paid. So I think that it's important that we have the willpower to appeal to the executive to release funds to the judiciary to meet these needs. And when these funds are released, it should be properly expended and in a transparent manner that can be seen and audited by the general public.
You know, I'm looking at the legal calendar, and I know that definitely there were cases meant to have been heard in the past 4 or 5 weeks that had to be, postponed, maybe indefinitely, because of the lockdown. A lot of people are waiting trial. I mean, there's a lot of things that are on hold, and I think that affects access to justice, which is the foundation of the judiciary. So what is the thinking for the coming days? Yes, you're still trying to tweak, video conferencing or e-sitting, but then there's still these real cases, people that feel that justice has been denied them during this period. So what is the thinking for ensuring that justice is served? Would they be postponed further? Would you let maybe people, the judiciary now, would you let people with lesser offenses off the hook? What is the thinking generally?
Well, I think that it's time to appeal to the Presidential Task Force to change the content of the guidelines. For all intents and purposes, law should be considered as essential service because law is humanity. It is second to nature. The only reason that ensures human existence is because of law, which regulates human conduct and gives us a guide on how to do things. So to that extent, we should ensure that as long as the police are working, the law enforcement agents are arresting people, they have a right to be defended by counsel of their own choice, not to be imposed on them or taken to mobile court, arraigned, and they are given a lawyer by force and sentenced one way or the other. So that is the first suggestion that I'll make to the Presidential Task Force, to consider law as essential service. Secondly, we as lawyers and stakeholders within the administration of justice must be ready to make sacrifices because what we are facing is a global challenge and we should embrace it as such. So to that extent, I believe that by the time we get around all this, we cannot afford to go on long vacation of the usual July to September vacation of the courts because of time that we have already lost. So the proceedings that can be conducted online for non-contentious applications and the appellate process should continue. But just like every other professional, engineers, accountants are bearing these laws, we as lawyers must also get ourselves ready to count those losses as part of sacrifices to society. But by the time we get around this, we should abolish the long vacation for this year and ensure that we take the 3 months of that vacation to continue to conduct proceedings so that we can decongest the prisons and then clear the backlog of cases that have been pending due to the lockdown.
All right, now, yesterday, there was a lot of focus on the House of Representatives, but eventually, it appeared the Speaker did bow to pressure, people asking that a lot more be done about that infectious diseases bill. Having now said, yes, it will now be put to the public hearing such that people can go in there and then make their own contributions. What do you now think? What do you expect to happen? Because first, we wonder when that will be, since we're still grappling with COVID-19, and then people talk about the need for us to do something about the current situation in terms of legislation. What do you see happening about this bill?
Well, I think that the people in the National Assembly are our representatives, at least based on the Constitution. They were elected to represent us. So they cannot do any representation that is against the interests of the generality of the people. From opinion that one has been able to assess so far, it's clear that that bill should not be considered. It should be withdrawn. There's no need for public hearing. It's a bill that's going to lead to dictatorship. I've checked the bill, 44 pages, 134 times is the Director General made the reference to. the Director General was mentioned 134 times, giving such enormous powers to become like a dictator. So I believe that looking at the bill generally, it runs totally in violation of the Constitution because, for instance, the minister has the power to declare a place as an isolated area. And if he has done that declaration, the Director General then has the power to restrict your movement. And if you are dissatisfied, you can make an appeal within 7 days to the minister. And when the minister gets the appeal, his decision on it is said to be final. So the minister has become the Supreme Court. You cannot challenge him. You cannot even go to court to challenge his determination of an isolated area. And you can imagine what goes on in Nigeria about abusing power. I mean, you can just go and declare the secretariat of the opposition party as an isolated area without giving any reason. And there's no appeal. The minister has the power, or the Director General rather, has the power to declare a gathering illegal and ask a meeting to disperse without giving any reason. So I think that generally, from the look of the bill, the contentious areas outweigh the advantages, because I look at Section 7 and 12, for instance, which allows postmortem for any person who died of suspicion of any infectious disease. That is good. And we eliminate what is going on in Kano and some other areas where, for religious reasons, people have to be buried immediately without autopsy. So Section 7 and 12 is being able to take care of that to ensure that there must be a post-mortem examination and that the corpse should be disposed in such a way that it will not constitute nuisance to society. Those are commendable areas. But when you look at the sections of the law generally, for instance, Section 24, which allows the policeman or a health officer to apprehend somebody without warrant, you can imagine what that amounts to just go to somewhere and say, I suspect you that you have an infectious disease. And you know how many infectious diseases exist? Even coughing is infectious. HIV is infectious. So you must first make a declaration based on verifiable data that there is an infectious disease called pandemic, called COVID-19, whether it's called polio or whatever. You won't just generalize it to say anybody I suspect to have any infectious disease. For God's sake, tuberculosis is infectious. So the police and the health officer will just go anywhere, and when they don't like your face, they just arrest you and say, I suspect that you are coughing. And I think that's a problem.
Oh, no,
and a person will be...
Just one moment, get this straight. Are you saying that the bill should be thrown out outrightly? Because from what you have said now, generally the bill, is too dictatorial, and are you saying it's completely out? It should be completely thrashed?
Well, you see, when what you would do to amend a process is more than what you would do to reenact it, you then take your choice. From what I have seen, the contentions in pointing out the illegal areas of the bill outweigh the advantages contained in the bill. So what do we do in that regard? The process and energy of amending those obnoxious sections outweigh the advantages of retaining it. So it's better for the House of Representatives. And I must say this, I like to commend the Speaker and indeed the members of the House of Representatives, because from my own observation of this particular House since their inception, they've embarked on pro-people activities. The Speaker sponsored the bill to limit the discourse from giving estimated bills and several other wonderful bills that they have sponsored. So I think that at times they may err. And in that regard, we should encourage them to do what is right. So I do not agree with those who are saying they probably have been bribed or they have some other ulterior motive. People can make mistakes. Maybe it's out of their own enthusiasm or out of legislative exuberance to take care of what we are facing now that they have come up with this. But of course, people have pointed out that it is just the same thing with the Singaporean Infectious Diseases Act of 1977. And I've checked both. There are too many similar sections. And if that is correct, that bill was enacted under a dictatorial regime in 1977. It's not proper for our own circumstance. And this is the reason why I said they should withdraw the bill, harmonize with the Senate, and come up with a new bill that conforms with the Constitution. The Constitution grants a right of freedom of assembly and association. How can the Director General of NCDC go to somewhere where people are having meeting and ask them to disperse just because he suspects that there's an infectious disease or to demolish a house? A law should be meant to help people. Somebody is infected, you want to help him to treat him. So by the time you finish treating him, he comes back, he discovered that his house has been demolished, which is double jeopardy.
All right, Mr. Adegboruwa, Senior Advocate of Nigeria, we have to thank you very much for your time and perspectives this morning. Thank you so much
Thank you very
for
much.
your time.